Danna-Gracey webinar today on workers' comp changes that will affect your practice. For those of you that don't know, Danna-Gracey is the largest independent medical malpractice insurance agency in Florida, and they have a statewide team of specialists dedicated solely to insurance coverage placement for Florida doctors and healthcare providers, including medical malpractice, medical facilities workers, compensation coverage, physician and employee benefits, and PEO. So today you guys have the pleasure of two presenters, Tom Murphy and Julie Danna, who are with Danna-Gracey and who are both experts in practice management as well as workers' comp. And with that, I'm going to pass it over to Tom.
Thank you, Wendy, and thank you everyone for taking the time out of your busy schedules today to join us for this webinar. And what prompted this for us was, as many of you probably know already, the landscape for workers' comp in Florida is changing, and it's not just for medical practices, it's for every business out there. And what I mean by that, and we'll get into it in the discussion, is that we've had some recent Florida Supreme Court decisions that have altered the legislative reforms of 2003 and 2004 that are having some dramatic changes on the system and have already started what is going to be about a 15% rate increase effective December 1st. So in addition to the rate increase, there's some other updates and changes you need to be aware of, and that's what we're going to try to accomplish today. We won't take a lot of your time, but we thought it was very important to do this. And so what we're going to be talking about today are these items here. I'm going to get you started shortly here with Julie Danna, and she's going to just kind of give everybody a brief overview and history of the system in Florida. We're not going to go into too much detail on that, but we want to give you a background of it so you're familiar with it, and then talk about some of these Supreme Court decisions in brief to let you know what they were about and the effects that they're going to have on all of us in terms of whether you're in a medical practice or a business, and then some of the changes you need to know in terms of regulatory compliance with OSHA, the rate increase, of course, and the challenges for Florida workers' comp system as we move into 2017. Also, a few pointers, if you will, about protecting your practice and protecting your employees. So preventing workplace accidents and ways that things that you can do to offset any future rate increases. So with that being said, I'm going to jump right into allow Julie here to start her presentation and give you a little background on our Florida workers' comp, and we'll let Julie go.
Hi, I'm Julie Danna, and I've been with Danna-Gracey since the beginning. I'm more of a storyteller than a technical person, so I thought I would just take you guys through a short recap of what's happened in Florida with workers' comp. Workers' comp, according to Wikipedia, is a form of social insurance. We don't really think of it as insurance. We think of it as social insurance. It provides wage replacement and medical benefits to employees who are injured in the course of employment, and in exchange for mandatory relinquish of the employee's right to sue his or her employer. It's purchased through standard insurance companies, through a fund. A lot of people have their own self-insurance plan. The next slide, Tom. Mm-hmm. The workers' comp, basically in Florida, the very first workers' comp law that was ever passed was in 1908 by the encouragement of Teddy Roosevelt, and that was the Federal Employees Liability Act, which helped certain government employees who were hurt in the line of duty who were working in the hazardous industry. And at the outrage of many, Teddy pointed out that the burden of the accident fell upon the harmless man, his wife, and children, because before that, they had to prove that they were hurt and that there was an economic loss. So everything kind of stayed steady in that world until 1930. And then Florida had no industry, so they decided they wanted to attract people to come to Florida, not just for tourist seasons, but for careers. And so when they started doing that, it actually, by the time 1935 came along, people were starting to get hurt, and so lawsuits started to come. So Teddy Roosevelt, in his New Deal, that was signed in May 23rd, 1935, and became effective in 1935, also in July 1st. So along we come, and during a time of chaos in Florida, because there was a huge hurricane that hit here with 250-mile-an-hour winds and hundreds of people were missing, there was the Florida Industrial Commission was formed, and that was responsible for administering the provisions for workers' comp law, making the studies investigations with respect to safety provisions and causes of injuries to employees. And life stayed okay until then, and then in 1979, they decided to change the name from workers' man's comp to workman's comp, which to me is very easy, much easier to say, and wage loss concept was adopted, replacing the fixed benefit system. 1990, I thought was interesting. That's when they brought in the workplace, drug-free workplace. And then in 2003, when things really started to change in Florida, it's where they started to pay attention to the attorney fees and the structure. And from 2003 to 2008, and Tom, you can switch to the next slide, we actually had 6 rate decreases in Florida. During that time, Florida went from the highest to the second highest rates in the entire country, down to the top 3 best rates for reduction in attorney fees. Between that time, the largest rate increase, which was a 60% rate increase overall, was an 18.6% rate increase in 2008, and another 15% in 2007. And then Tom, the final slide.
Yeah. There
was a case in Florida called the Westfall case, and what that was, it came in and it changed the timing for the disability for a person that was hurt. So they had the investigation time from 104 weeks to 260 weeks. This fellow was totally disabled and was unable to prove his permanent disability, and they were going to cut him off from his benefit. And that was in 2014. And then in 2016, Castellano versus Next Door Company had a big case regarding the legal fees. And the decision was to remove the fee structure that an injured worker's attorney could afford for excess fees that were widespread across the legislative. What was happening is the attorneys had been capped so much on their fees that they were afraid to take cases, and what that did was reduce the lawsuits in Florida, which helped bring prices down. But in this case, the attorney was only getting $1.53 per hour for 107 hours worth of work. So at the end of it, he only made $164 compared to what he should have been paid, $337,520.
And Julie, let me interrupt you there real quick.
Sure.
One of the things I want to make clear to everybody is with both of these cases, Castellanos and Westfall, these are cases that were cherry-picked by the lawyers to bring to the Supreme Court. They were certainly not standard everyday workers' comp cases. These were kind of the outrageous fringe type cases, which, as you can see from what Julie just said, you know, the attorney got a $350 fee instead of $37,000. Now, obviously, the argument would be that, you know, $37,000 is too much, but $350 is way too low. So they were able to get the Florida Supreme Court, the current Florida Supreme Court, to rule both of these cases as being unconstitutional. However, it's really important to keep in mind that the vast majority of workers' comp cases had no outcomes even similar to this. So it's as many of the defense attorneys have told us, these were fringe cases that kind of caught the eye of the Supreme Court. And of course, as you can see by reading them, they're somewhat outrageous, but they certainly are not the norm.
Yeah,
sorry, Julie, just wanted to make sure I add that.
I'm great.
And hey, Julie, before you go back in, I'm getting a lot of feedback from participants that they're having a really hard time hearing you. So if you can please speak up so everyone can hear you.
Okay. Thanks, Tom. Basically, it was all about making sure that they could assure the quick and effective delivery of disability medical benefits to the injured worker. So in
Julie, we're
2006,
still having a really hard time hearing you. I don't know if you can pick up the phone and not talk on speaker. Really hard to hear you.
okay, can you hear me better now?
Much better, Julie. Yeah.
Okay. Well, basically, that's kind of where I was leaving off. Now we're at 2016, and many experts believe that the current rate increases of the 14.5 will be the first, unless we can make some changes to counteract the Supreme Court decisions, which will be difficult since the court ruled that the prior reforms were unconstitutional. And this is where I was going to let Tom take over.
Thanks, Julie. That was really interesting, especially with these two court cases. And to add to what Julie just said, basically any work comp claims from January 1st of 1994 till now that are open or that have not settled, which there probably are not a whole lot from back in that period, but these two Supreme Court decisions ruling these laws unconstitutional basically sets everything back to 1994, which is where the injured workers had 260 weeks for temporary total disability, and also attorneys had much higher fee schedules. So those two things combined are what is making these changes with rates important, and it's really one of those things where between the Small Business Administration, the legislature, the insurance carriers, and everybody else, they're going to have to put their heads together to see what can be done in the legislature to change these Supreme Court decisions. They're not going to change the decisions, but they're going to have to do something to counteract what's been done, because they basically have taken away all of the reforms of 2003 that have made the system very workable and very affordable for everybody. It's not like we're hearing that there are injured workers all over not getting the benefits they need. It's typically the plaintiff attorneys that put all of these changes into motion because they're not getting the fees that they want. So like anything else, whether it's workers' comp or malpractice or any other form of liability or law, the attorneys have a big say in that. So what this has done and what it's going to do is it's going to provide incentives for injured employees to seek additional medical treatment, to extend their time on disability or extend their treatment time, because they are now going to go back to the 260 weeks instead of the 104 weeks that were changed with the 2003 reforms. It will also incentivize plaintiff attorneys, because the attorneys now, knowing that the fee schedule has been thrown out, they'll have an incentive to keep their injured workers treating so that they continue to get benefits and the attorneys continue to churn their fees. That's kind of always been the argument that you see over the years with regards to, the business population and the legal entities out there, is this cat and mouse back and forth about it, and we look at it in our business as a pendulum. The pendulum swung to one side after those 2003 reforms. Julie mentioned it, where you had over a 60% rate decrease in all of that time. I remember with medical practices in 2002, the rate for medical practices, physician clerical, was $1.05 for every 100 in payroll. It's currently 42 cents. So we can all see the dramatic decrease that those reforms had. And now with these recent court decisions, those are going to change and start heading back north again. And so that's kind of what we're looking at this point, and the purpose of our discussion today. So in addition to that, you're going to have some OSHA regulatory compliance changes. Most of them are not going to affect a lot of the medical practices. If you've got a medical practice with 20 or more employees, then you got to start looking a little more closely at the way claims are handled and the way that they're presented and reported. You still have to take all of the precautions that you have in the past, regardless of whether you have 1 employee or 500 employees. So as we all know, everybody in the medical world knows that the last 7 to 8 years, we've seen an amazing amount of regulation between HIPAA, MACRA, everything you all have to deal with on a daily basis that has just burdened everybody, from physicians, administrators, office staff, to everybody. And this is another area that has changed. Now, there may be a bright outlook in the future. As you all know, from the past week, we've had a change in leadership in the country, and that may help to change things. We don't know. We don't know where that's headed, other than to maybe have an optimistic outlook that a lot of this regulation that we've seen implemented in the last 7 or 8 years will be changed or overturned, so that especially physician practices won't be so burdened and can actually take care of patients instead of filling out forms and dealing with regulatory issues. So anyway, the OSHA is going to increase civil monetary penalties for any basic violations that you're caught with. What used to be a base average fine of $7,000 is going up to $12,000. So that's just for little things. Could be paperwork, could be misreporting, could be anything that they don't consider serious. Any serious violation where maybe you've done something to place your employees in a position where they could get injured, those are going to go from $70,000 up to $127,000. So the OSHA has decided that they're not sitting down anymore. They're going to take this all very seriously, and this goes back to what I said about the regulation changes. So they're going to improve the tracking of the workplace injuries. Typically, when you have that 20 employee or more practice, you're going to actually have to file what's called the Form 300, which is found on the OSHA website. Whenever you have any type of serious injury, that form has to be reported. And typically what they do is for companies, large companies, you have to at least get that form into them once a year with all of the injuries that have been reported in the company. That form is found on their website at www.osha.gov. And that they'll give you more information. I don't want to get into too many details about that because it's too much to discuss it for this webinar. So that being said, one of the other things that they're doing now, which I find very curious, is when an employer reports an accident with injury through these forms, OSHA now is putting those on, they're posting them on their website, basically without any hesitation. The whole purpose of it is to shame employers. And if you read their website or other articles about this regulation and what they're doing, it's clear that this is basically what they believe, that by getting employers to report it and then showing the general public what the injury and accident is, they can shame employers from making their workplaces, or to make their workplaces safer to avoid these injuries. But in the meantime, you're now putting a company's public information or information about an injury out to the public, which isn't always going to seem fair. So I suspect you're going to see some changes with that in the not too distant future, but that's one of the things they're doing. Another thing very important for all medical practices as well, and any business, you cannot in any way discourage employees from reporting an injury or a claim. That's always been the case. However, OSHA is now looking at that more seriously. They have found that there's been problems with that, where employees are discouraged in a number of different ways from reporting claims, and you certainly are not allowed to do that in any way. In fact, you encourage them to report it, because at the end of the day, with workers' comp, it's different from other forms of insurance in the sense that if it turns out to be nothing and they're not treating, et cetera, it doesn't affect your policy at all. It doesn't affect your premium at all. The only time claims can affect your policy premium is if there's a lot of money paid out on them, and that, like any other insurance, that can affect it. But just reporting a claim does not do that, and contrary to other forms of insurance, you really have to. You're required to do that by the insurance company and by OSHA. So important to do that. Don't discourage your employees, especially one of the things that's confusing is they're talking now about drug testing, and many of you out there may have drug-free workplaces in your practices. If you have written drug-free workplaces in your practice, you're going to be safe from most anything. However, with drug testing, you're only supposed to be drug testing when you suspect that drugs or alcohol are being used, et cetera. However, if you have a written program that spells out, and all employees have been given that written program, and it's been discussed with them, that tells you when you're going to drug test, how you're going to drug test, as long as they fall within the OSHA guidelines, you're fine with that. And that's not a form of discouraging them from reporting an injury, because it's within your rights as an employer to have them drug tested if you have this policy in place. And that will never change. So, well, at least we hope it won't in Florida. Some states are very lenient on it, but anyway. Moving on here, we've gone over the fines already. We'll talk very briefly, Julie already mentioned it, about the rate increase. NCCI, which is the National Council on Compensation Insurance, is kind of the governing body of workers' comp for all states. They get with the state insurance departments, and they're the ones that get together and determine what rate reductions or rate increases are going to be, et cetera. They came in after these Supreme Court decisions and wanted a 19.6% increase based upon what they felt were going to be the changes in costs incurred to the system. The Department of Insurance agreed upon a 14.5% increase across the board. That's for every employer, regardless of what business you're in. So effective December 1st, 2016, everyone paying for workers' comp will have a 14.5% rate increase. And quite frankly, we don't expect those rate increases to stop until the legislature can get involved and do something to counteract these Supreme Court decisions. So we're hoping that happens in the spring, because they're certainly not going to do it now since we just had a national election. Moving on, Julie had already mentioned, I'm not going to touch on that, but Florida was one of the worst states for workers' comp prior to 2003. Up to last year, it was the third best in the country in terms of workers' benefits, rates for employers, and stability. So that is probably going to change and start heading back in the other direction unless we see some changes. So some future challenges, sorry about the screen there, future challenges for the system. Obviously, we just discussed higher costs. The second one, greater regulation. Now, we've seen some greater regulation, but like I said earlier, that may change over the next year due to a new administration, et cetera. We may see things lighten up a little bit, but nobody knows at this point. So we're just going to have to keep an eye on that. And then moving forward on that, as I said earlier in the presentation, I love that little, as everyone can see, the little cartoon that Steve put in there for all monsters having to wear their helmet and safety glasses. That's very clever. So the key here, the takeaway on this is really preventing workplace accidents and injuries and ways that you can offset future rate increases. And to touch on the first, everybody that is in a medical practice, that is an office manager, an administrator, a physician, you're going to try to do everything you can to prevent workplace accidents. Obviously, there's some unique twists with medical practices because of the exposure to hazardous chemicals and things of that nature. So there are a lot of great resources on the OSHA website that you can go to. There's a lot of great resources that we have here at Danna-Gracey where we can help you navigate some of the things you need to be aware of in your practice. And also what I would say is, OSHA never really has had my medical practices is that you should have at least 2 safety meetings a year. And they don't have to be specific safety meetings, although certainly that would be encouraged. You can include them in whatever other meetings you're having in your office. But you want to talk about safety. You want to talk about having a safety platform or plan in place, and things that your employees need to be careful of and look out for and report. Of course, the biggest thing here is communication, including your employees and everybody in this discussion, getting their input, getting them to tell you if they see what they believe is a hazard, getting them to report those things so that they can be changed. Obviously, you're looking out for those things throughout the year, trying to make sure that you don't have any hazards on the floor, that they're wearing the proper shoes, that you're dealing with needles in the most effective way to prevent injuries. And by the way, those of you that don't know, needle sticks are the #1 claim we see in medical practices. So be careful with needles and deal with them the way that you're supposed to and dispose of them the way that you're supposed to. You're not always going to prevent these accidents. It's just human nature, but taking the steps to do that is going to help. And we can help with that. We have written safety programs that we can pass along that are samples that you can use to implement for your practices that will help you. In addition, you have the comp carriers that you're with have in Florida a 2% credit if you have a safety program in place, and that's real simple. It's a one-page application, and you just send in a copy of a sample safety program that is OSHA approved, which we have and can provide to you. You get a 2% credit on the workers' comp. Drug-free workplace, if you have that in place, you should be getting a 5% credit from your work comp carrier, because that allows certain businesses that have the drug-free workplace written policy. And then the only real caveat to that is you've got to contract with a certified lab so that they consider it legitimate. And of course, that all employees are aware of the program. It's written, it's in place, and it's consistent with every employee. That's the key word, consistent. And then, like I said, have a couple of safety meetings. If you do more than that, great. Obviously, when you're onboarding any new employees, you want to go over the safety stuff as well for any new employees, in addition to those other meetings that you're having. And then ways that you can offset any future rate increases. Obviously, we just got done talking about some of the safety things. Those are going to be imperative to keep you from having high rates. You can't control the rate increases that the state puts in place, but you can counteract those. And obviously, having a safe environment where you're not having accidents and injuries will help you save money on the premium in the long run. In addition to that, there are dividend programs out there. I've put up a screen here where we have exclusive dividend programs that pay up to 30% return every year. And this is something that everybody that has private insurance for workers' comp needs to be a part of. We have all of these exclusive programs that can give you money back every year that can counteract that rate increase that you get. So if you're not a part of them, look into them. Either ask your agent or contact me or Julie or any of us here at Danna-Gracey. We're happy to let you know about them, but that's another way that you can do it. And as we finish up here, before I take any questions, I wanted to mention also, we're going to have another webinar with Acevedo Consulting on November 30th at 12 o'clock regarding Section 1557 of ACA, Patient Affordable Care Act. And you can see there what it's in relationship to. Very important for you to attend this to learn what these details are about and these changes are about, because there's going to be new requirements and training for staff as well. So that webinar is November 30th. I believe it's a Wednesday at noon, and we hope you all attend that. And with that, I want to thank you, and let's see if there's any questions here. Wendy, are you seeing any questions on the?
Yeah, I have a couple, and for any of you that want to ask a question, you can just type it into that area on the webinar, and we'll get to them. So one of the questions, Tom, is do we need to purchase the workers' comp posters for our office?
Wow, that's a good question, and not one we often get, but the answer is no, absolutely not. There are companies, and I've seen this, there are companies out there that will send you kind of dark threatening letters saying if you don't have these posters, you are not in compliance with OSHA and so on and so forth, and they sell you a packet of posters for $200 or $300. Everyone who has workers' comp insurance in Florida should be getting a poster, a workers' comp updated poster every year from their work comp carrier. And if you're not, you need to call your agent or the work comp carrier and get them to send it to you. That poster has to be placed in a location in your office where the employees have access to it so they can see it. And in addition to the verbiage on it, it's got to have the phone number for your insurance carrier and your policy number so that an injured employee can contact them directly if they need to. Obviously, you want them contacting you rather than your insurance company directly, but you're required by law to have that, and you shouldn't have to be paying for it. Your carrier should provide it.
Okay, great. Another question is, we have corporate officers and need to know if they can be excluded from the coverage.
Wow, this is a really good question and very important because we get this all the time. I don't know if it's lack of education on the agency force out there or just greed or whatnot, but corporate officers of any type of corporation, whether it's an LLC, PA, Inc., whatever it is, corporate officer, managing partner, partners, etc., can apply for exemption from a work comp policy. You first of all have to be listed on SunBiz on the corporate information as an officer or a managing partner, etc. So once you are legally listed on SunBiz as that, then you go into the state website, the Department of Insurance, and there's a 2-page application you do online. It takes 2 minutes to do it. And you apply for exemption for that officer. Administrators can do it for their doctors, whoever their owners are. And once that's done, we submit that into the insurance company and request that that officer be exempt from coverage. Not all physician owners want to be exempt. We certainly don't recommend it for surgeons, for anybody really, because you can be hurt on the job no matter what you're doing. But a lot of them opt to be out of it because they don't want to pay that additional premium, or they have other insurance that they feel they're comfortable with. So the simple answer is absolutely exempt your officers. It's a simple process. We can help you with that. You know, it's something if you don't know, ask your agent and ask your physician or your owner if they want to be exempt. It's really important because it's their option and it could be a savings on the premium. So.
Great. A few people are just asking if the presentation is going to be available after the webinar, and the answer is yes. Anyone who registered will get a copy of the webinar and a copy of the presentation.
Right. Great. Well, I want to thank everybody for attending today, and I want to thank Julie especially for helping me out and providing some great information, and for Wendy, thank you for putting it together, and thank you all. We look forward to seeing you on November 30th at the Affordable Care Act update webinar on 1557 compliance, and thank you all again.
Okay, it's my pleasure too, and just wanted to make one last comment. If the doctor exempts himself, make sure he has a disability policy, because that's really important. Yeah. Thank you, and I'm sorry some of you couldn't hear me, and I'm happy you joined us.
Yep. Have a nice Thanksgiving, everyone.
All right, bye-bye.
Bye-bye.